Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning. This is the March session of the Court of Criminal Appeals in Knoxville. We are glad that you're with us this morning. Our panel is Judge Kelly Thomas from Maryville, Judge Robert Montgomery from Kingsport. I'm Norma McGee Ogle from Sevierville. The arguments are 20 minutes per side. If you would like to save some time for rebuttal, please let me know before you begin your arguments. We are ready for the clerk to call the first case.
Jarus Smith versus State of Tennessee.
Mr. Krieger.
Yes, ma'am. Thank you. Good morning, Your Honors. As she stated, my name is Matthew Krieger. I am of the Williamson County Bar here in Middle Tennessee, and I represent Mr. Jarus Smith. I'd like to reserve about 5 minutes for rebuttal, please.
I will note that.
Thank you, ma'am. As the court's aware, this is a post-conviction case now. It did go to a jury trial in the courts below. The charges here arose out of a prison incident at the Turney Center in Hickman County, Tennessee. Judge Easter tried the case back when he was a trial judge riding on the circuit for the 21st Judicial District. There are two attorneys that participated in the trial. There was an attorney appointed to represent Mr. Smith. I'll refer to him as trial counsel. Apparently, according to the record, that would have been the first trial for trial counsel. So the court got another attorney involved to help out who had a lot more experience. I'll refer to him as elbow counsel. At trial, though, practically speaking, elbow counsel did a lot of the heavy lifting. And I don't believe elbow counsel was compensated for his work on it. In any event, the case went to trial, and Mr. Smith was convicted of facilitation of attempted second-degree murder, possession of contraband in a penal institution, and 2 counts of aggravated assault. And now the post-conviction proceedings are underway. And the reason we're here is we're alleging there was an issue with the composition of the jury. We're making 2 arguments here on post-conviction. Number one, that the convictions violated Mr. Smith's right to a 12-person jury. And number 2, that he received ineffective assistance of counsel with respect to the advice given on whether to proceed at trial with a 11-person jury. It was an 11-person jury that rendered the verdicts in this case. And as the court knows, a jury has to be composed of 12 people, and the verdict has to be unanimous here in Tennessee.
I'm not sure if it helps you or not, but Judge Thomas and I believe, were both on the direct appeal panel for this case.
Yes, ma'am. I feel ashamed that I didn't recognize that when I read through the direct appeal, because I did read through that. So I'm sorry I didn't note that. So you do have a familiarity with it then, for sure. And the court may note, I guess I can address this now, that this issue of the composition of the jury wasn't raised in the trial court for motion for a new trial or on direct appeal, but it would be our position that it didn't need to be, because one of the issues here is whether or not Mr. Smith waived his right to a 12-person jury. And obviously, trial counsel and elbow counsel participated in those proceedings relating to that alleged waiver. So we would argue that it would have been a conflict of interest for trial counsel or elbow counsel to raise that issue on a motion for a new trial or on direct appeal, because they would have been putting at issue their own advice and their own conduct in the proceedings related to the waiver of that right. So we're raising it here on post-conviction as we contend it's a proper issue. A little bit of background to get back to that. Basically, the case was tried, the proof was closed, and the judge dismissed the alternate. There are 13 jurors who listened to the proof. The judge dismissed the alternate. That alternate on the way out after being dismissed had a brief conversation with one of the alleged victims. So that basically disqualified that alternate in the party's eyes from further service. And that was one of the reasons why the alternate couldn't come back. But in any event, the jury began deliberations. And then shortly after that, the trial court informed the parties that an issue had arose and that one of the jurors had become sick. And the trial court basically gave two options to the parties. But we would contend that there was really only one real option. And the two options were to go forward with 11 jurors or to wait for the juror to get better. Now, I say only one real option. And I'll point out before we get to my point there, I'll point out that this is all contained in, there's two records here. There's the post-conviction record, obviously, and then there's the trial record that Judge Thomas and Judge Ogle are already familiar with, obviously. And it's volume 5 of the direct appeal or trial record, as we can call it, starting at page 374, where all this occurs with respect to the trial court informing the parties that the juror had gotten sick. And the trial court basically, as I said, informs the parties that this juror had gotten sick and felt like he couldn't continue to serve. And what's interesting is that, I believe the trial court was doing this in wanting to be efficient and finish the trial just like any good trial judge would. But there's a spot in the record on page 375, I believe it is, 377 actually. I'm sorry, where Mr. Smith, who is trial counsel, said that that he wanted to talk with his client about whether or not they're going to be willing to go forward with 11 jurors. And the trial court jumps in and says, well, we'll go forward with Mr. Warren. That's the name of the sick juror. We'll go forward with Mr. Warren before I'll agree to if you're going to ask for a mistrial or something like that. And Mr. Smith, trial counsel, says, no, we're good. And the court then says, I'll force Mr. Warren to get better. And the court reporter noticed laughter there in the record. And so our argument is that the trial court wasn't very serious about willing to wait for the juror to get better, that it was basically, the parties were in a position where it was kind of being forced on them almost to go forward with 11. Now, the record does contain what the state's going to allege is sufficient evidence to constitute a waiver of a 12-person jury, because we fully admit that the law is such that you can waive your right to a 12-person jury. You can waive your right to a jury in its entirety. Obviously, people do it every day when they settle their case and plead guilty. But if a waiver, as the court knows, of the right to a jury or the right to a full 12-person jury, is a waiver of a fundamental constitutional right. And I won't say much about this because the court's well aware of it, but it's hard to think of a more important right in our system than the right to trial by jury. I was looking back at some of these older cases in writing the brief, and there was one that kind of caught my eye from 1874, and that was a very trying time, obviously, for the United States and Tennessee especially. We weren't getting a whole lot of things right at that point. It was aftermath of the Civil War, and Reconstruction was still underway, but the court back in 1874 still got the right to trial by jury correct. And they said that this right is guaranteed to every citizen, and any statute which fails to secure the full enjoyment of it is necessarily void. They continued, it is not necessary for us to recur to the origin of this institution or to trace its history in order to appreciate its inestimable value in free government. So they got that right. That's the 1874 case, Neely versus State, that I cited in my brief. But getting back to my argument, our position is that the record is insufficient to establish a waiver of a 12-person jury. It is true that the trial court did ask twice whether or not Mr. Smith wanted to go forward with a 11-person jury. And he did say he did, but it was never explained on the record to Mr. Smith that he had a constitutional right under the Tennessee Constitution and under the United States Constitution, for that matter, to have a 12-person jury. And really, nor was the practical impact of that explained to him, because as the court knows, and we take a lot of this for granted as attorneys, but our contention is it should have been explained to the client or to the defendant that that means that not 12 people but 11 people are going to consider your guilt or innocence, and that the state's only going to have to convince 11 and not 12, and to get a unanimous verdict in order for you to be convicted. It didn't change the burden of proof, obviously, but it made it a little easier, obviously, on the state if they only had to convince 11 people and not 12, because it's not a matter of every vote counts. Every single vote has to be in favor of guilt, as the court knows, and that's one less person that the state has to convince if you drop the jury from 12 to 11. And I know it might be kind of an apples to orange is comparison, but you might think, well, what difference does it make, 12 or 11? Well, in football you have 11 people on the field, but go try to tell a coach that he's only allowed 10. You don't need 11 people to run this play. You can block it with 10. One person makes a huge difference in football, obviously, and I think arguably that could be the case in a jury trial as well. One other juror, who knows? And to that end, the state may also argue that, well, okay, fine, there's been a violation of the right to a 12-person jury. Well, what's the prejudice? Well, that's already been addressed in prior case law. That was the State versus Cleveland case cited in my brief. That's a 1997 holding, and basically the court took the position that when you have a problem with a fundamental right, such as the right to a 12-person jury, that it's not subject to harmless error analysis. And the court said, quite frankly, that it would just be impossible to show the prejudice. How could you? We'd just be speculating. But that wasn't the point. The point was to the court in the Cleveland case that it's such an important right that any violation of it, is prejudicial, and that would certainly be our contention here. As far as the testimony at the post-conviction hearing, Mr. Smith, who was elbow counsel for my client, testified that he recalled discussing with his client that he had a right to a 12-person jury, but couldn't recall exactly what his words were. Excuse me, he was elbow counsel. I apologize. Elbow counsel who conducted the trial was the one that said he had the discussion with Mr. Smith, but couldn't recall what he said. It was trial counsel, and I know it gets a little confusing. He said that he didn't have a conversation with his client about this issue at all. And Mr. Smith, my client, testified at the post-conviction hearing that he was never informed. Obviously that the post-conviction court, made its findings of fact, and the court can go look at that. But our argument is that this is a right that's worth protecting, if there is any right that's worth protecting, and that is the right to a 12-person jury. And the record's insufficient to establish a waiver of it. It's very. We would argue that it was a very minimal, just almost token type proceeding to where this issue was addressed, and that there was no explanation of the constitutional right, again, to the right to trial by jury, and there was no explanation of the consequences. Mr. Smith was not given an opportunity really to consult, a meaningful, lengthy opportunity to consult with his attorney about it. It was done really quickly in the record, and that's our argument. I'll reserve the rest of my time for rebuttal. Thank you.
Thank you, counsel.
Yes, ma'am.
General Smith.
Good morning, Your Honors. May it please the court, Colleen Smith on behalf of the state. I first want to note that the petitioner's claim that he didn't knowingly or voluntarily waive his right to a 12-person jury is waived because he could have raised that on direct appeal and did not. But I will address the very closely related ineffective assistance of counsel claim. The trial court gave him the option of waiting for the sick juror to get better or to proceed with the remaining 11 jurors. And as opposing counsel noted, both sides objected to recalling a dismissed juror because he had spoken with one of the victims on his way out of court, so that just was not an option. Mr. Smith, who served as elbow counsel, testified that he had explained to the juror that he had a constitutional right to the petitioner, that he had a constitutional right to 12 jurors, and that he could either wait until the sick juror was feeling better or proceed with the remaining 11. Counsel explained that this right was just fundamental. Those were his words. And he also explained that he believed that they had a good jury with the remaining 11 jurors, and therefore at the time he thought it was best to proceed. Mr. Bohms, who also represented the petitioner, confirmed that Mr. Smith had spoken with the petitioner about this issue. And the petitioner admitted at the post-conviction hearing that he understood that he had a right to a 12-person jury. That's volume 3, page 19. He also acknowledged that he had waived his right to a jury trial in numerous previous guilty pleas in unrelated cases. The post-conviction court accredited Mr. Smith's testimony that he had advised the petitioner of his constitutional right to 12 jurors, and the court properly concluded that the petitioner had knowingly and voluntarily waived this right. I've cited to the Delmer Hall opinion in my brief, and I'll just note that the facts of that case are extremely similar to what we have here, and this court found that counsel was not ineffective under these circumstances. Here, counsel explained to the petitioner that he had a constitutional right to 12 jurors. The petitioner even admitted that he was aware of this right. He's not established ineffective assistance of counsel. And if there are no further questions, the state respectfully asks that you affirm.
Was there a break in the proceedings once the problem was recognized in order to give counsel time to speak with the defendant about that?
Yes. Yes, Your Honor. The transcript reflects, although it didn't capture the conversation between counsel and the petitioner, the record does reflect that they did have a chance to discuss it.
Thank you.
Thank you.
So, General, you don't think the fact that the lawyers who would be pursuing the issue of not waiving the right to a 12-person jury were the lawyers that were involved in advising him and helping him guard that right is an issue?
As far as the waiver?
Correct.
No, I do not. First, I'll note that that's really not what happened. They did advise him of this right, but notwithstanding the fact that they did advise him of that right, there's no reason the petitioner could not have raised this on direct appeal. I think we've all seen cases where attorneys have brought up an error that even they participated in, or if the petitioner strongly felt that he didn't understand this right, he could have requested other attorneys. He had the opportunity to raise this on direct appeal and did not.
Okay, thank you.
Thank you.
Mr. Krigler, you have all of your rebuttal time and a little more.
Yes, ma'am. Thank you. And I'll be brief to address your question, Judge Ogle, about a recess. The transcript reflects on page 376 that an in-court recess occurred shortly after the parties were informed of the issue of the sick juror, and we would argue that that's hardly ideal. The record does not reflect that the court took a full recess and allowed time for the parties to discuss it in any more length. And if the court takes a look back at the transcript, the court will see that this was kind of happening. Some of this was happening as the parties were kind of coming back from lunch, I believe. So it was kind of in the fog of trial, so to speak, that all this happened. Everything happened in the fog of a jury trial here. And to address Judge Thomas's point about the waiver issue, I hate to do hypotheticals, but hypothetically speaking, if Mr. Smith had pled guilty, didn't have a trial, but had pled guilty with trial counsel and elbow counsel as his attorneys, and then Mr. Smith wanted to challenge his guilty plea by arguing that it wasn't knowing and intelligent. Certainly, if elbow counsel and trial counsel participated in that plea proceeding, it would be inappropriate for them to in a lot of circumstances argue on appeal that their own advice, that their own counsel was deficient. I mean, I think that any prudent attorney would realize that would need to be handled by another lawyer, and that's why we have new counsel appointed usually or hired for post-conviction proceedings. And unless the court has any other questions, I'll rest, Your Honors. Thank you.
Thank you. Thank you, counsel, for being here virtually. We're hopeful that before too much long, we can be back in the courtroom. Thank you for your good arguments, and that concludes this case.
Thank you.
This court is now in recess.